the scope of the right of paternity is really straightforward, that every time the work is used, the work has to be attributed to its author. The right to divulge the work still, it's of public nature, and therefore, if there is an agreement between the author and the work and the publisher, and the author decides at the 11th hour not to publish his work, he or she can exercise the right to divulge the work, not to comply with the contractual agreement. The right to withdraw from circulation is very, very much like the French system, that it's there, but you have to do three things. First, you have to exercise it through the court. Second, you have to indemnify the second party who might incur any losses. And thirdly, that if you are going to republish the work, you have to give the right of first refusal to the initial publisher under the same terms and conditions. The right of integrity is the most interesting aspect in the civil law countries of the developing countries. Why? Because they learned the game from the developed countries. So they have two different standards. They apply one to their own nationals and completely another one to foreign nationals. And who said that the developing countries are not fast learners? The right of integrity, it is very wide. However, there is a problem with it that most developing countries that follow the civil law system do not really comply with the second part of the Berne Convention of Article 6 bis, which is the spirit of the work. In comparative copyright law, the right of integrity covers two things. It covers something called the form of the work and something called the spirit of the work. The form of the work, which covers any deletion, addition, alteration. The form of the work is when you use the work as it is in its intrinsic nature, but in a context that was not intended by the author. Most of the civil law countries in the developing countries forgot or ignored the latter part, and therefore they protect the form, but they do not protect the spirit. When it comes to the criteria that governs the application of the right of integrity, it's subjective criteria. What does that mean? It means that the author has the last say. Unlike in the United Kingdom, when the author has to suffer and to prove to the judge that he has an honor that's worthy protection, and then he has to prove, or she has to prove to the judge that there was a damage to this reputation or honor. In the civil law countries, in the developing countries, or the author's rights systems, you don't have to prove any honor because dignitas, it's something that's given to you by birth. And therefore, you don't have to spend any time or get expert witness for that. Furthermore, you don't really ask how the work was perceived by the public. The court would follow the subjective view of the author as long as the author is not abusing his or her right. Now, there is a problem with such wide scope of the right of integrity. Why? Because the developing countries need to have access to foreign works. And if you give such wide protection to foreign authors, you will hardly be allowed to translate a single work without getting into trouble. So, although the Berne Convention Appendix, which was adopted in 1967, but never came into force, of course, till 1971, because the 1967 Act of the Berne Convention was never really ratified by a single developed country, caters for the needs of the developing countries, this appendix. It caters for the needs in terms of translation and reproduction. But since the developing countries also have moral rights, a foreign author can come and invoke moral rights, especially when it comes to translations. So the developing countries, or most of them, came up with this fantastic trick. And the trick is, no. When it comes to foreign works, the right of integrity is applied objectively, not subjectively. The author can't have the last say in it. How? Most developing countries came up with this extra provision after they mentioned the right of integrity and the scope of the right of integrity. They say when it comes with respect to translations, it would not amount to an infringement of the right of integrity if the translator mentions in a footnote the place of omission, deletion, or addition, or if such alteration is prejudicial to the honor or reputation of the original author. Whereas in all other aspects, when you read the right of integrity or the scope of the right of integrity, the laws of the civil law countries and developing countries normally mention his or her reputation, i.e. it's subjectively. It's according to his view. Whereas when it comes to translation of foreign works, they apply the right of integrity objectively. Why is that? It's to allow the developing countries to have access to foreign works. Because the appendix on its own is not good enough. Because moral rights can still hinder the flow of works to the developing countries. Now let's talk quickly about the common law countries. The common law countries followed the UK approach and made exactly the same mistakes, and they are very proud of it. So the first thing is they have right of paternity. More often than not, it's subject to formality requirement, and therefore it doesn't apply automatically, but the author has to assert it somehow. The right of integrity, which applies objectively, not subjectively, i.e. the author has to go through all the trouble of proving honor, reputation, and then that such honor, reputation has been damaged. And thirdly, that they introduce a right called false attribution, which is, of course, a UK invention, because the right of false attribution is not really a moral right stricto sensu at all, because it benefits authors as well as non-authors. So really it shouldn't be under copyright law to start with. And all the moral rights are waivable. So if you look at the copyright law of Barbados, Botswana, you'll see that moral rights are waivable, but strangely enough, they are unassignable. You cannot assign them. As for duration, unlike the civil law countries in the developing countries, the common law countries in the developing world, they adopt a term of protection that's linked to the economic rights. So it's 50 years post-mortem octorius. Now, the last point I want to conclude with is that why the developing countries started now taking moral rights even more seriously in the last 6 months or 8 months. The reason is very simple. If you are following the WIPO negotiations now on the protection of traditional knowledge and expressions of folklore, you'll find that the text that will be discussed on the 7th of May, within the next 6 weeks or so, is really recognizing some sort of a moral rights protection to protect cultural heritage. And that's why the developing countries are supporting the text. Whether anything will come out of this text or not, whether it will ever be a treaty, God only knows. But it seems that this trend is not only at the national level, but also at the international level, that moral rights are being extended to cover cultural heritage. I think I'm just on time.